Hey, hope you didn't lose yourself in the first exam. Um, First exam is over. We move on to the next one. We focus our attention now on the actual crimes. So, with chapter 4, what we're going to do is um, literally start looking at the actual crimes that have substance. There's we've already laid the foundation, and now we're saying, okay, now what crimes can come out of it? And this is, we talk about like parties to a crime and everything like that, because this is where you're looking at like accomplice liability, um, looking at who is part of a crime, and then we start carrying over into the specific crimes. So, um, thing to remember in this chapter is we got to differentiate between um, mens rea and actus rea. Mens rea, mental state, disgust. Actus rea, physical, something tangible, something that you do. But now, when you're helping somebody, what does it take? Because this is a fine line in criminal law and really law as a whole. At what point can we punish thoughts? Because when I plan to do something, it's all in here, okay? But is that illegal? Is it illegal for me to think? And it's definitely a fine line. So that's something that I want you to keep in the back of your head as we're going through that. Where do we cross the line, and which theory are we going to follow? You know, each state's a little different. That's why I teach kind of a broad spectrum of what can be used. But I want you to understand that that's really what this comes down to, is when you're planning a crime. Because, I mean, you can all think about times when you really wanted to do something, and usually it's a violent crime. We don't plan little things. You know, we plan the big stuff. You know, we think about the big stuff. You know, you may think about robbing a bank when you're having financial difficulties, or you may even think about robbing a liquor store or something, or you may think about killing an axe or something. That happens, but that's not illegal. But when does it cross the line? So uh, that's basically what the objectives talk about. You know, what's the difference between aiding and abetting, accessory versus principal? When do we cross the line with an affirmative action versus an omission, just like with any other crime, honestly? Um, how do we get to that point that we cross the line? And again, with any crime, we always have to deal with what a mens rea is and the actus rea. Very important with any statute that you're dealing with is, when you're interpreting the statute, always look for what the mens rea is, and then what act has to come together with that. So, you know, I plan to do something, but what act is there? So my thought and my actions. So let's get into it. Let's do this. What's an accomplice? An accomplice is someone who is taking part in a criminal act. Doesn't it's speaking in broad terms. It's speaking in broad strokes, really, because anytime you help as an accomplice, plan, assist them in any way, be it hiding them, not divulging information. Some statutes are even so stringent, because the purpose of these statutes, the aiding and abetting statutes, accomplice statutes, all that stuff, is we're discouraging A, criminal enterprises, B, this concept that I'm going to have somebody else act on my behalf, in order to, I have a criminal thought in mind, and I use somebody else to do it for me. and now I can wash my hands of it and I'm not responsible anymore. We want to make sure that everybody involved, because I mean, think about that. If I had the ability, there was no accomplice liability, I could send I feel like, Gru, I think that's his name, Gru, and his little minions. I could go, minion, go do this. I'm not responsible. See, every time, and then all this stuff gets done that's illegal, and I'm off the hook. So we want that to be eliminated. And then the obvious, we want to discourage people from helping criminals. So that's what we're looking at here. And that's what we're trying to accomplish, is discouraging those behaviors. An accomplice is anybody who assists. Now, aiding versus abetting, most states have kind of combined them to anybody who assists. We don't differentiate between aiding and abetting. Aiding is actively helping, and abetting is not harming, not discouraging in any way, not slowing down the process, not reporting them. Aiding is literally going, here's a gun, go get it. I'm going to go buy you a gun, or I'm going to get one off the street. Here you go. That's aiding in someone doing a crime. Whereas abetting would be more along the lines of, I know he's committing a crime, and there are ways that I could hinder that in some way, even up to and including turning them in, and I don't do it. We kind of lump those together and go, look, if you're responsible as an accomplice in any way, you're going to be on the hook. And that really comes down to what accomplice liability is. How much liability in the criminal sense? There's more in a civil sense, as we've learned earlier, that civil liability is much easier to attain. But criminal liability, there's still pretty decent amount of criminal liability in assisting people committing crimes, and even not hindering them in any way. So just looking at that, we want to keep that as we go forward. We're trying to discourage that, strongly discourage that. Therefore, we're very broad in how we approach it, but we can't cross over into what I refer to as like mind please. I can't get to that point where I'm going into your head and saying, hey, you can't do this, or, we're trying to avoid that. We can't go that far, but there are limits. So it's a principal versus an accessory. A principal is a person who does it, someone who actually has their hands dirty. That's how I refer to it, as the guy with the dirty hands. And sometimes your accessory doesn't have clean hands either, honestly. Because your principal is somebody who is the active participant, the one that pulls the trigger, the one that walks through the door of the liquor store, those types of things, where the accessory is the guy driving the getaway car, the person that helped you get all the stuff, goes to Halloween USA and gets you your mask and all that fun stuff, right? That's the accessory versus the principal. Now, I don't expect you to differentiate between the first and second degree principal and first and second degree accessory, because that's getting what I refer to as nitpicky, and it's not on the exam, and most even on your bar exams, because I look at this as kind of a pseudo law class, like law school class. So I don't look at it in that respect. But just for the knowledge purposes of it, the first degree principal is a person that is doing it, like literally. Whereas many states differentiate a second degree principal. There's a fine differentiation, because you look at the definition: one who intentionally assists in the commission of a crime in his or her presence, such as present may be actual or constructive. So they're considering a person who is like the getaway driver or the lookout, because they're assisting by being present. That's kind of an important distinction, because some states look at that as being more of an accessory before the fact or accessory after the fact. See, terms that we will get into that Michigan doesn't use, but a lot of states still kind of rely on that. That's almost a pseudo common law issue. But principal in a second degree is you're doing something, but you're not actually doing an underlying crime. But in most states, if not all states, I know Michigan, you are treated as the principal if you took any active role. That's why we don't differentiate between a first and second degree principal. If I am the lookout on an armed robbery, let's say person A goes in, I'm lookout, and person B is sitting in the car. We're all going to be treated the exact same way. We're all going to be treated as principals in that armed robbery, even though I didn't actually go in and rob the liquor store. Somebody else went in and pointed the gun at the clerk's head and took the money. I actively participated in that big picture act. That's the way Michigan looks at it, and you're going to be treated as the principal. You're going to be treated at you committed armed robbery, even though you didn't walk in the door. And a lot of states have gone to that as a discouraging, definitely a discouraging word there. You know, if you know that you're going to be held responsible, in theory, some believe that this deters people from kind of taking part. Some it does, but those that are in the criminal element don't care. And it doesn't necessarily mean a physical presence. It can also mean a constructive presence. You knew about it, and you were waiting around the corner to help him get away. But you're close enough to actively assist in the process. Usually there is the element of mens rea, though, that you have to know what's going on. Like, for example, let's say you took your friend to a liquor store and, with the intent, like, you're at a party, okay? Put yourself at a party and your friend says, hey man, we got to make a beer run. We've all been on beer runs. I've been the DD for a beer run, and I've also been the runner. We go in and I'm driving and I'm like, hey dude, I'm gonna wait outside, man. You just run and grab beer. He goes in and robs the liquor store. I didn't know he was robbing the liquor store. I gotta actually have knowledge, and leaving, you're gonna be hard pressed as a prosecutor to say, hey, you're gonna be considered an armed robber at that point if you didn't know going in, because how are you, if the guy comes out running with a gun, how do you stop that at that point without being in fear of your life? And that could be the issue. I actually represented a guy who robbed the bank like that. He actually robbed the bank, and he went in with the premises he's drawing money out to go get parts for a car, and he comes out and he would rob the bank. And his friend he met in jail had driven him there, but his friend was smart. He looked and he goes, dude, this doesn't make sense. And he sped off before the guy got in the car. So the guy ended up carjacking somebody to leave. Yeah, let's make two wrongs make a right here. It generally doesn't work. And they got him on videotape, both inside and outside. It was actually kind of comical. Watch that dye pack explode in his pocket and the color drip down his leg. So it's not like it was hard to find this dude. But point being that the guy picked up that the participant, the principal, was coming out, and it looked suspicious that he was running out, and he knew. He's like, no, I'm getting the hell out of here. And he got in the car, exited really quick. So that's kind of a rarity, though. I mean, that would be obviously how you could delineate, hey, I had nothing to do with it. But even if he drove away, I think there'd be an element, especially if it's armed robbery, because then would it have crossed over into, like, say, carjacking or something like that if he obviously pointed the gun at him? But I mean, you could claim that as the other accessory. So there's, where do you cross the line? You have to have some element of mens rea in order to be take part. So constructive doesn't necessarily, it isn't the mere fact that you have to be in on it. You don't have to just be near. So remember that you're not always guilty just because your presence is there or near. Many states still use these archaic terms, accessory before the fact, accessory after the fact. Michigan has gone away from it only because um, it's just easier to say, all right, here's the deterrent. If you had any knowledge and you didn't do anything before or after, we will just charge you as the principal. Have a nice day. And armed robbery is the easiest one because it's probably um, relatively common. I don't want to say robbery is common, but it's something that you can easily see. Um, accessory before the fact would be the dude that said, hey, helped him case it out, maybe went and bought the gun, stuff like that, or gave him the gun. He had his own gun or something like that. An accessory after the fact is, he comes running in, hey, hide me, the cops are coming. Or, there was a recent case where the lady, it was around here too, she knew that her brother had robbed someplace and actually killed the clerk. So she got in the car and drove him to Texas. Um, yeah, I think that's a little bit of aiding and abetting. That would be a classic example of accessory after the fact. Because she knew he robbed the store. What was she supposed to do? Nothing. Usually you can get away with not doing anything. Some states have an affirmative action requirement where, look, if you know something's going on, you got to report it. Most states, we don't have these snitch statutes because, the risk of harm and all that stuff. So, but there are a few states out there that have that affirmative. The only way you can stop it is to just rat on them. I don't know. I mean, that's what it comes down to. But the code of the streets is snitches get stitches, so you got to be careful. So many states have kind of taken that into consideration. So modern parties to crime, we've kind of alluded to that. Common law separated categories aid and abettors to distinguish punishment, but under modern law, we're all charged as principals. Most states now, can you be charged separately? That's kind of your out. A lot of times what states will do is they'll keep the aiding and abetting statutes on the books as a leverage tool. That's probably the best way of putting it. That way I can get you to turn on somebody else. Hey, you drove the car. I'm going to be okay with you, man. I'll just charge you as an accessory, and it's a lesser charge, and I'll offer you that if you roll on the guy that actually pulled the trigger, that type of stuff. So some of them use those leverage tools, but most states have gone completely to, in practice, in utilization, just charge them as principal because we can. And then you use that as like a plea out, something as a lesser included offense. Now, actus rea, what act do you have to take? Again, it is statutory in most cases, and they're pretty distinct in how they do it. You must do some sort of affirmative act. Planning, in most cases, planning isn't enough. You have to do something to take steps toward carrying it out. Okay. But in a lot of states, that act doesn't take much. Some states are so strict that merely writing it down would be enough of an affirmative act. Obviously the thought isn't there. You can't use just the thought, but above and beyond that, maybe not, right? Anything above and beyond that with some states. Other states are more conservative on that, in the sense of, and I don't mean that in political sense, I mean that in the conservative view. They're going to give you a little more credit. They're going to be a little more conservative on that and go, let's make sure we have something for sure. Can it be physical? It can be psychological, is what we mean by saying, hey, when you want to do this. I represented somebody who was upset with another person, and they said, hey, how about you put something in his Red Bull? So in the state of Michigan, the guy that said, hey, is the one that is also considered a principal, and that's a 4-year felony, by the way. introducing a foreign substance into another person's food or drink, 4-year felony. And they just thought it was a joke, which is kind of interesting. Yeah, and it was something that really didn't do any harm. But the person that went, hey, let's put this in the drink. Did you see that movie? It was like Wedding Crashers, I think it was, where he put saline in the guy's drink and the guy was in the bathroom for the rest of the night. Yeah, that's what they tried, and it wasn't very effective because it's not true. Um, Saline doesn't do that. High quantities makes you have diarrhea, though, just for the record. So at what point the influence is enough, and then the dude that says, here's the saline. I mean, so hypothetically, you got 3 kids sitting around in a cafeteria, and there's some guy that's been bullying them. You got one kid say, hey, I think that movie The Wedding Crashers is kind of funny. I think we should do it to that jerk over there. Kid sitting on the other side says, well, it just so happens I have a bottle of saline for my eyes. Here, would you like to use it? And they kind of go back and forth, and they go, okay. And then the third kid goes, I'm going to go do it. He goes over and drops it in. So now all 3 of them are held as a principal because they all took affirmative acts toward that end goal. There you go. That's how it works. Act by omission. The model penal code uses this, requires a person to act with the purpose of promoting or facilitating a crime in order to be held liable. Model penal code doesn't like the omission. Mere knowledge of a crime or failure to stop a crime is not enough. Some states have gone above and beyond that, where you have a duty to act. Going back to civil law right there. They create a duty to act within the statute, saying, look, if you know of a crime, you're gonna, and I don't think it's, most of them, yeah, because I think the challenge would be difficult on that one. If you made it a felony or tried to treat them like that, to actually make it a felony along with the other felony. However, there are some states that kind of push you in that direction. But again, as I stated before, the snitches get stitches. We take that into consideration. We probably shouldn't do it. Shouldn't have statutes like that because you're putting people in a very difficult situation. Model penal code doesn't like it, but some states still use it where just merely knowing of it and not reporting it isn't enough. Now, keep that in mind, though, later on, we do have a requirement for that in the same chapter where if you've already conspired, then you have to do something to correct the conspiracy in order to avoid liability. Accountability. Model penal code does provide that a person is an accomplice if they solicit to commit a crime. In fact, you're considered the principal completely. Hey, kill my wife. Here's $500, and I'll give you another $500. I don't think $1,000 would be enough to kill somebody's wife, but hey, whatever. If they are a drug addict, they might want it. You're considered your conspiracy to commit murder and murder. A person aids or agrees to attempt to aid in a crime, has a legal duty to prevent commission of a crime, and fails to act properly. That's the difference between the general citizen and somebody else. If you have a duty to prevent a crime, you're in a situation like, it could be something as mundane as being an accountant for a large firm, and somebody's embezzling and you don't stop it. You could be held on the hook because you have an affirmative duty. That one's probably one of the better examples. Because when you look at other situations, the layperson versus layperson, you're not going to see that duty. But maybe security guard, obviously police officer, but police officers generally don't do that, but you can. And then obviously ineffective assistance may be an attempted crime. So you could still be on the hook if you assist somebody and it still doesn't come through, but now you're on the hook for the attempted whatever, armed robbery, rape, murder, or whatever. So first case in this area, this is the Stansel case. Kind of interesting because it falls under that omission. The mom and boyfriend, they had a court order that said that the mom had to, or let me back up a second. There was a court order that said the boyfriend wasn't allowed to be near the kid. And the Mom ignored the court order and said, "Oh, no, no, it's okay," and he killed the kid. And Clark said, "Well, you had a duty, not only as a parent, because we talk about that a little later, but not only as a parent to protect your child, which is an implied duty that all of us have as parents, but then now you have a court order above and beyond that, because you kind of go back and say, well, that's really what a child abuse statute's about, right? Or child neglect statute. When you're dealing with a child neglect statute, I have a duty to provide for my child. If even now she's not even over 18 to some extent, I feel duty minded. But if you're a parent, that's how you have the mens rea required for child neglect. So now, not only did you have your inherent parental duty, but then you had a court order above and beyond that. Yeah, you're probably going to be on the hook for something. You're going to be in trouble for something. Be bare minimum child neglect and child endangerment. But let's go above and violating that court order. I think you should be on the hook for the homicide itself, because you had that duty to stop it, both parental and legal. But and this case kind of solidifies that. Mens rea of accomplice. A person is accomplice if they aid or assist, possess the intent to support or encourage the crime, or intends that the primary party commit the underlying offense. That's a very important part. You have to truly intend that the party's going to get completed, go to completion. And that's kind of the out that sees quite frequently. There's an out there. Hey, I thought he was joking. Or he was drunk. He says that stuff all the time. That type of stuff is not the biggest out, but you can try it. Then they're going to kind of focus the attention on you and go, well, should you have known better, that type of stuff. But that's a pretty decent way of kind of negating all that other stuff. You got somebody that's, big mouth drunk, and they do their thing, and you're like, oh yeah, right, he said that a million times. That might be a decent out. Because again, we want to discourage it, but we don't want to be an overburden here. And they have to have the intent to carry out the underlying crime. So, I'm only doing it in jest. I was only joking. I thought he was joking. Or the that they can't complete the crime. That's another one. You knew that person couldn't complete the crime. You put blanks in the gun or something. He was mouthing off, so you gave him the gun, but it was empty. Well, yeah, you probably shouldn't have given him the gun, but are you going to be held on the hook for the murder? Probably not, because you gave him an empty gun, and you didn't know there was ammunition in the house, or you didn't know he had a way of going to get ammunition or something like that. Now they may get you on gun charges or something, because you shouldn't give your gun away. You're not allowed to do that. But getting you on the hook for the actual murder, probably not. So there must be purpose and knowledge. You're going to get a mental state that we're a meeting of the minds there, that we're both agreeing on what we think we're agreeing on. It's almost a contract. I hate to kind of put it that way, but I think it is. Because when you have a contract, you have offer, acceptance, consideration, and there must be a meeting of minds of what you're offering, accepting, and considering. And you say you're going to, especially if you're at an arm's length, you say you're going there to break into the house. And I say, look, all right, all right, cool. I'll drive the getaway car. Well, or I'll meet you around the corner to help load or unload, or I'll let you hide your stuff at my house. That's another good one, because now I'm putting myself even at a further distance. You're going into break into this house to steal the TV and all this other stuff, right? Well, I agree that I'm going to let you store the stolen materials in my garage. Fine. Well, you end up going in there and committing a rape and murder and steal that stuff. I was just trying to cover for that. I was just going to hold your stuff. I wasn't involved and I wouldn't be on the hook for the rape murder, but I probably would have some liability for knowingly accepting your stuff. Now, if that's my ongoing operation, I wouldn't be held responsible for the actual. If that's what I do all the time, I'm not going to be held responsible for the actual robbery. I'm sorry, burglary, using proper terms, right? I'm not going to be on the hook for the burglary, but I can be possession of stolen property, obviously, because that's just kind of my gig. But I don't think there's enough of a connection in order to get me on the hook for the other stuff. And mere knowledge that one's act facilitates a crime that not necessarily establish accomplice liability. You have to do something to help. Again, very few states have that knowledge basis. You have to do something to actively help. But that line may be thin, and that line may be that bar may be pretty low to say, what did you do to help? What were you doing to help? Was it something as simple as helping them plan it out, helping them case it out? That's still an affirmative act. Just the fact that your brother comes in and goes, hey, I'm going to rob a liquor store, I'll see you later, probably isn't going to get you in that much trouble. Especially when you don't know if it's true. Now, these are two terms that people get confused, because one is someone, basically what entrapment is having the government, keep that in mind, the government get you to do something you wouldn't do. And that's the important part about it. When an officer or agent of the government, so that's one element, for the purpose of instituting prosecution, so they want to charge you with a crime, they induce, they have to do something to induce an innocent person, somebody who would normally not do this, to commit a crime. So you got to have those 5 elements in there. That he or she had not contemplated. That goes back to, would prove that you're an innocent person. So the example I often use in this class and a few other classes, is the difference between entrapment and not, I guess, is if you're staying at a hotel and I send a hooker up to your room, and you open the door, hooker comes in, and I send it to your room and you had no clue what was going on, and you pay the hooker, that would more be entrapment, because you didn't take an affirmative step to commit the solicitation. Technically, you didn't solicit him. I gave her to you, or him to you, depending on your perspective, whomever was sent to your room. I gave him to you. Where it's not entrapment, if you're looking through the back pages of the local magazine for a call girl, and you call and you happen to get the one that's a cop. That's not entrapment. They always try to pull that, the Johns anyway, when law enforcement officers pose as a prostitute, and they go, well, you entrapped me. Well, no, you were driving down the road and you called her over. Now, if she comes up to the car, there's got to be a little more, she kind of slow down, so that gets her the enticement. She comes over to the car and, hey, what are you in the mood for tonight? And now you've got to do something that makes it obvious that you know that there's a prostitution issue here. And once you cross that line, it's not entrapment anymore. You know what you're getting into. So that's something to keep in mind. Whereas an agent provocateur is someone who intends for the principal to fail in his or her illegal venture, and because of this lack of causation is not an accomplice. Entrapment is where the government gets you to do something you're not supposed to do. Agent provocateur would be like, I want to get my brother in trouble, and I go, hey, let's go break into this house, and I know, all right, I assume, that you're not going to be able to do it. So I just kind of push you in that direction and, do what you're supposed to do. Um, and you end up technically succeeding. Um, Someone who intends for the principal to fail in his or her illegal venture and because of this lack of causation is not an accomplice. Basically, I know you're going to screw it up, or I assume you're going to screw it up. So whether you do it or not, my intent was that you were going to screw it up because I thought you were a screw up in the first place. That's what an agent, I'm just, egging you on. An agent provocateur is an egger honor. We all have that brother. We all have, well, I don't have that brother, but we all know somebody who's that will egg you on but never do it themselves. That's what an agent provocateur is. They provoke you to do something. Here's some cases. This one is the defendant did not benefit from the sale of marijuana, though he directed the police to the sale. That case was just what was he an accomplice in the situation? He knew about it. He was actually just more of a rat more than anything else, and that's what the court came up to. The Wilson case, I think, is really funny because that's similar to one I just mentioned. These guys had been committing burglaries together for a while, and he was mad, so he set up his partner. Well, oops. But he wasn't an accomplice. He set him up. And the Twig case is the example of entrapment, because it's honestly a difficult defense to try to put together an entrapment defense, because the government tends to cover their assets, and they don't want to put you in a situation like that. They've got enough real criminals to go after, so it's not a big deal that they're going to entrap you. Now, there has been entrapment situations, A, when crime rates were a lot lower, and B, when they were specifically targeting like Al Capone and people like that, where we know they were doing something else, but hey, I can get them on this if I entrap them. And that's why the entrapment laws came into effect, was to stop that stuff, because look, get them on real stuff or leave them alone. And they basically, this was 1978, but they basically taught the guy to be a drug dealer, had him do drug deals, and then arrested him. That's entrapment. But again, we talk about, where's that line? It's got to be a police agent. So, your sibling can't entrap you because they're not an agent. They're not getting, well, they may have the intent of you getting criminally prosecuted, but it's not the government with the intent of criminally prosecuting you, getting an innocent person to do something that is illegal. An innocent person, it's something, innocent is the big broad category, a person who normally would not have done that. And that's a hard thing to kind of counteract. How do you know somebody wouldn't normally do that? I don't know. And that's usually the biggest defense when somebody claims entrapment. The government will come back and go, how do I know you wouldn't do it? You did it, obviously. And that's true. That's kind of a low burden, I think. I think that's what I would consider a low burden, because you did it. And once you say that you've done it, how can you claim that you wouldn't do it? Because you just did it. I know it's like the chicken or the egg argument, but it is difficult to kind of differentiate. So that's why that's a legal argument to be discussed in court, I guess. So what's the extent of accomplice liability? It can go far, but you have to, the doctrine that we use is the natural and probable consequence doctrine. So look at an act and say, what could the natural or probable consequences of this act be? A carjacking, could that turn into a murder? Mm-hmm. A carjacking that could turn into a police chase. Mm-hmm. A carjacking that could turn into a negligent homicide because you run somebody over. Mm-hmm. Natural and consequential. A carjacking that turns into an armed robbery. Huh? A carjacking that turns into a Rape? That's natural. See, and these are all examples. Somebody takes the car with the intent of, carjacking. You got two people working together to carjack someone. Sometimes somebody will pull up, dump them off, they jack the car, and then they usually go to a chop shop to take the car or something like that. That's usually what carjacking does. If you're that trail car and the guy shoots them, natural consequences. You're that trail car and that guy takes off and runs somebody over, natural consequences. You're that trail car and that guy drives off and rapes the driver, not natural consequences. That's not what we anticipated. And that's generally how you look at it. Is that something that would naturally come out of that? Or, he takes the woman's purse and writes bad checks. What? Wait, where'd that come from? Yeah, that's not a natural or probable consequence of that carjacking. I was just a rear driver. I dumped them off. I thought I was in the car. We're going to chop it up and have a nice day. I'll get my money out of it. I didn't think he was going to write bad checks. And that's true. And the court wouldn't put you on the hook for the bad checks, but they would definitely put you on the hook for assisting him. And that's what the natural and probable consequence. But you're on the hook for any of those. Any additional act necessary to accomplish a criminal goal will be considered natural and foreseeable. So the homicide, a lot of the stuff that goes along with it, it's part of it. And the case law is not very forgiving on this. It's definitely pretty broad when it comes to what are natural consequences. So keep that in mind. Like killing the security guard, killing somebody in the bank, any of it. Anybody in the bank, any of that stuff can be considered natural consequences. Somebody mouths off in the bank robbery. That's where a lot of these natural consequences things come from, like armed robberies, bank robberies, that type of stuff. They tend to come out of that because, it takes more than one person a lot of times to get it done right. And if one gets a little trigger happy or gets that itchy trigger finger, boom, somebody's dead. Yeah, well, you should have thought of that before you went in there. We don't want you to rob a bank. Did you not catch that at the beginning? We don't want you to. So if this is what the outcome is, then so be it. You should have thought of that. Natural and foreseeable consequence. It can extend to negligent, reckless conduct on the part of the primary actor. And that's where it does kind of differ from state to state. Reckless behavior, some states may not hold you on the hook for the careless driving that runs somebody over in the carjacking example. Some states may not do that. Michigan will. Michigan will put you on the hook for that. But some states are going to go, no, well, we didn't think that you would drive recklessly while driving away from a carjacking. Personally, I think that's probably how the only way you're going to get away. You're not going to get away going 10-2. Okay, let's go. I don't see that happening. But again, some states are a little more, conservative on how they apply that. What is considered reckless behavior? Luparello was an interesting one because she was on the hook. I believe it was a she. It was basically a secretary who knew that this boyfriend had something against the victim, and she gave him the address. This is why we have a lot of these security provisions in places of employment. You're not allowed to release information about your employees. It's very limited for this reason. You never know when there's something there. And she was held on the hook for the homicide, or she was taken to court for the homicide. She wasn't held for the actual murder, but she had some contributory actions. In the Riley case, this is the reason why we have accessory and why we treat him as a principal. This case right here, and there's a bunch of them before this, but this is a recent one. If there's three of us shooting at somebody, and the person dies, you're going to get into a huge ballistics argument over which bullet killed the person. So we eliminate that argument altogether. Anybody who pulled the trigger, and if the bullet hit them, yep, there it is. And in fact, even if you have a really crappy shot and you miss him, you intended to shoot him, you're going to be on the hook for the murder. This eliminates all those arguments. That way you're not sitting down there going, well, this 9mm versus this 9mm to come out of that gun or that gun. You know, all of y'all. Everybody's going to be on the hook. So it's to eliminate the argument and discourage multiple people doing the crimes. I think the book example was, there's another one in the book, I think, was a beatdown. And, you know, how do you prove that? It's a little easier to prove with ballistics, especially with our modern science. I can narrow it down to the gun that fired. And, you know, when you get the bullets out of it, you probably narrow it down to the actual gun. And then say, okay, this is the gun that this person was holding. There it is. Boom, here it is. But what about a beatdown? You know, which one blow, you know, they kicked him in the head and in the chest and everything else. Which one of those actually was the fatal blow? That one's going to be a little harder. So we just go, all right, well, y'all kicked them. Done. Some states will kind of pull back and go, we only kicked him once. He kicked him 8 times. Well, we should not. Thou shalt not kick thy neighbor. But again, you know, we're trying to decriminalize in some areas. So, but a beatdown's a beatdown, right? So you probably should avoid that in the first place. So, relationship between the principal actor and accomplice. Are you an innocent agent or an instrumentality? An innocent agent / instrumentality is using something that someone or something, because I mean technically there are people that are in this category that are incapable of doing it on their own. This would be cruel and unusual punishment, but you strap explosives to your dog. Ugh, God, that makes me sick. But it came in my head, so I must be sick. And you know, go blow somebody up. The dog doesn't know the difference. Or, I mean, we do see this fairly frequently in some areas, using the dog as a weapon. You know, you've got a dog that you've really trained to be attack here, you know, and you get them riled up and you just send them off, and that's an instrumentality. An innocent agent, technically we kind of use the terms interchangeably, but that's more of an instrumentality, using a person or something else to do it. Whereas an innocent agent is a person who doesn't understand the right difference between right and wrong. They have some mental illness. They have some level of mental incapacity. And you tell them, hey, you know, go do this. They don't know the difference, and they're acting on your behalf. In a way, it's like the minion. You're going to be on the hook. Actually, you're going to be on the hook more than they are. Because they don't know the difference. You know, you have somebody with the mental capacity of a 6-year-old with Down syndrome, for example. You tell them, "Hey, go steal that. They won't get mad at you." Yeah, that bad. You can't do that. Relation principle actable continued. Sometimes the act of innocent instrumentality is difficult to apply. There's certain classes the crime can be performed by only the person himself or herself, and it's not through that. That's what a non-proxyable offense is. Like, I'm the only one that can commit tax fraud on my behalf. I mean, I can commit tax fraud for you, but I'm the only one that can commit tax fraud for me. I'm the only one that can purge. I'm the only, not purge in the movie sense. Let me straighten that out. Perjury. I'm the only one that can commit perjury because I'm the one lying. I can induce you to commit perjury. I can say, hey, lie. That's not me committing perjury. I'm the only one that can commit perjury. Something that's non-proxyable is something that I can do because it's me. It's a me crime. So that's what non-proxyable means. And we punish the perpetrator or possessor of the intent. That's something to really just keep in the back of your mind. What we're doing is we're trying to, the person with the evil mens rea, and I use that term jokingly, but that's kind of what we're looking at. the person with the evil intent is the one that is going to be punished. That's what we're looking for. That's what we're trying to eliminate, is the evil in society. And we're going to punish that person. The other people, if we can prove there's no or less culpability, they will be either charged less or not charged at all. And this is where we get into the debates, I guess, sometimes. Like, for example, you guys are too young, and I'm technically too young for this one. Patty Hearst, she claimed that she was doing it out of fear. She was kidnapped, and then she robbed banks. She was trying to say that she had less culpability because she was doing it because she was forced to. Using the pure eyes of the court, we would say, you're right, you have less culpability, we're going to charge you less. But there was evidence the prosecutor was looking at, is that looks like she was trying to, completely all in on this thing. And in that case, then we want to punish her to the fullest extent of the law. So ultimately, when you're making that decision, you have to look at who has the most evil mind, and are they all equally culpable? Then they should all be equally treated. The feigning primary party is literally the opposite of an agent provocateur. Individual steps each person took in committing the crime is critical in determining whether the accomplice is criminally liable. What did you do to get to that point? Okay. Entrapment defense is available only when the conduct in question concerns a law enforcement agent or an agent of a law enforcement officer. So if I send somebody out on my behalf, or if it's me posing as a whatever, a feigning primary party is not in trouble. Think about it as an undercover agent. Oh yeah, I really want to sell drugs. Obviously it wouldn't be that obvious, but of course I'm here to sell drugs. Come on, I'm gonna give my street cred or whatever. That's just a feigning party. My intent is I'm gathering information for a prosecution on you. So that's what your feigning primary party is I'm definitely not an agent provocateur. I'm not pushing you in that direction. I'm following along with you to see where you're going to go. Entrapment test, was it induced by a government agent? That's the first step. And then, was the defendant predisposed to it? If you've been in the business for a while, you're not going to be able to claim that. You're not going to go, oh yeah, I really wasn't intending to sell drugs this time. But the other 30 times, something different, right? So that's the basic test. I break it down into the 5 elements because that's the way it's going to go in court. But that's your quickie test. This Sherman-Sorrells test basically says, first of all, you got to have a government agent or somebody acting on at their direction. And were they predisposed to the conduct? And the one that we use for criminal procedure, when we talk about the Hoffa case, all that dude was going in there and doing was getting information. He's just going in there and saying, hey, so I heard you bribed the juror. Ha, ha, ha. Good one, Jimmy. That's good. And Jimmy goes, yeah, man, it cost me $500,000, but man, I got that jury. I know I got a hung jury. Ha, ha, ha. I'm going to get off on this one. Didn't provoke him to do it. He was just gathering information. He knew he was taking part in it, but he's just gathering information. And yes, that dude was a paid informant by the government, but was that guy predisposed to do it? Yeah, Jimmy was predisposed. Dude, he already did it. He's gaining information. He's not there pushing him in the wrong direction. Does it go to a point where the provocateur or I won't use that term because I want to mix you up, but the person who's pushing gets him in that direction? Again, you can still push him in that direction. You can still go, hey, Jimmy, I heard you got the guy. Okay, well, if he's doing that, the guy still could be predisposed, so you can't use that as your defense, basically, is what it comes down to. Know that we're very, that line is very malleable because when push comes to shove, this is kind of a rule of criminal law and criminal procedure. Don't commit crimes. If I have evidence that you committed crimes, we're going to try our darndest to get it into court. So if you bribed the jury, I didn't push you to do it. I didn't put a gun to your head that said you're going to do it, so you're going to do it. And that's with just anything. I mean, how do you prove that you were or were not predisposed? And that becomes the linchpin. And if it's not a government agent, I guess, but that one's usually the easiest hurdle to get because it's a police officer or a police informant. It doesn't apply to anything else. I mean, if a family member says, "Hey, let's go sell drugs," you go, "Okay, I'm entrapped." No, they're not. Even if they roll on you, they're not entrapped. If they didn't come in there as an agent of the government. What happens if the principal actor is acquitted? Doesn't matter. You don't. It's the mens rea is the mens rea regardless of the outcome. Meaning, I intended to help him commit the crime, and he screwed it up. Oops. Under common law, the accomplice cannot be convicted of crime unless the primary actor was convicted. Our jurisdictions have kind of eliminated that because you end up getting attempt crimes and other things out of it, so you're not completely off the hook. Now, are you off the hook for the main crime? Maybe. Just depends on how many acts you did to get to that point. More than likely, you're probably going to be convicted of an attempt, simply because the act didn't go all the way through. And something to remember for the purposes of like plea agreements and things like that. For the purpose of a plea agreement, a completed act also fulfills the evidence necessary to prove an attempt, because if you completed it, you attempted it. You had to attempt. The first step is always in order to get something accomplished, you must take those first steps. Well, you took it. You took those steps all the way to completing it, so you must have attempted. I know that sounds weird, but it's true. So, somebody attempted to use drug. Somebody actually used marijuana, or at the time, now it'd be like cocaine. We could knock it down to an attempted use of cocaine. I tried to snort it, but it just wouldn't go. It's the same. Even the actual completion is enough for the attempt. And so any efforts in that direction could take you over that edge. Some more cases. The only reason Walser's here is to know that perjury is non-proxyable. I'm the only one that can lie for myself. The Vaden case, the guy knew or should have known, therefore they're considered still an accomplice, even though they didn't actually pull the trigger. They're taking somebody out on a hunting trip, and you weren't supposed to shoot, I don't know, a certain animal. I don't remember the case specifically, but basically this guy's taking some person out on their hunting excursion. He didn't actually pull the trigger, but he should have known that you're not supposed to shoot whatever he's shooting. He's shooting bear or something, and he didn't have a permit for that or something, so he's on the hook for the illegal hunting too. Then Eberhardt is again a non-proxyable. If I'm the Native American and I am immune from the hunting and fishing, but that doesn't give my spouse the right. It's non-proxyable. It's just me. I'm the only one that has that immunity. Same thing with like spousal immunity. It's my immunity. Attorney-client privilege. Attorney-client privilege goes both ways. They exercise their attorney-client privilege. I'm not allowed to say anything until they say something. But like spousal is another one. It's my right. I can't hand that off to somebody else. So if I want to blab, I can blab. I have the right to not tell on my spouse. But if I want to tell, I can tell. It's not her saying, "Oh gosh, you can't tell on me." No, 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 no. That's my right. I can say, "Hey, I don't want to testify against my wife," but she can't force me to do it. So that makes it non-proxyable. Limitations of and defenses to complicity. The first one is abandonment. Uh, Most states make you do uh, something um, profound in order to show that you abandon me. You can't just go, "No, I tried to stop." No, you've got to do something. Some states get to a point where, in order for abandonment to truly be uh, applicable and truly be an acceptable defense, you got to call the cops. Michigan's not that far, but you have to take some affirmative steps to stop it. And you've got to tell your accomplices, "Dude, I'm out. I'm not going to do this anymore. We want to rob this bank, or I was planning on helping you kill your friend or kill your business partner. I'm done, dude. I'm out." You got to do that in many states. And it has to be obviously done before the commission of the crime. You can't go, "Oh, I didn't mean to do that." No, you've got to do it before. So that's the basic premise behind abandonment. You have to take some sort of affirmative step to say, "Hey, I don't want to do this anymore." And most states require that you tell your compatriots. Some states even go as far as saying that you have to tell the police. Where do we cross the line between liability versus accomplice liability versus conspiracy? Good question. A conspiracy is really a partnership. It's kind of a contract. We have to have a meeting of the minds that say that two or more people are going to go out and do something. Commit tax fraud. That's something that kind of goes under the radar, but you and your accountant sit down and go, "Look, we both know you're really hiding money. Um, we're all both going to be on the hook for tax fraud if you get caught." That's why accountants try to be very diligent with that, So basically all it is a partnership, and all you need to have is an agreement that you're going to do something. Two or more people are going to do the same criminal enterprise. It's common, also called a common criminal enterprise. You just got to agree that that's what you're going to do. The difference between the two is what we refer to as the agency theory. The theory that all conspirators act as the agents or represent their co-conspirators involved in a criminal scheme and are liable for all criminal acts committed by any of the co-conspirators. We're all in this together. We're all here to say, "Look, we are planning to rob this bank." Keeping that in mind when you get back to the doctrine of reasonable and foreseeable, once you're in all in. And that's something that's why we do it, is to discourage this type of meeting of the minds. So an accomplice can derive from encouragement, assistance, or sometimes mere knowledge. Pinkerton, this is from quite a while ago, actually. The doctrine that holds a person associated with the conspiracy responsible for any criminal act committed by a co-conspirator if the act is within the scope of the conspiracy and is foreseeable result of the criminal scheme. We already talked about that, right? Reasonable, foreseeable. The model penal code doesn't like this, but many states do. Really, the difference is a person who is an accomplice doesn't necessarily have all the cards, if that makes sense. Like, you may know that I'm planning on doing something illegal and you give me a gun. A conspirator is actively participating, and you have to take affirmative steps to meet that goal. An accomplice is just, they know there's a crime going on, and you're either beforehand helping, but not necessarily knowing the full extent or planning it out or anything like that. And, or after the fact, hey, he did this crime. You can't have a conspiracy after the fact. So that's the other defining measurement. You have a conspiracy beforehand. So if you have accessory before the fact, we'll use that term, even though it's kind of archaic. If you're an accessory before the fact, when do you become a co-conspirator? When you agree that you're both going to partake in this common criminal enterprise, and this is your role, and this is their role, and this is what's going to happen. Whereas an accomplice is somebody who assists, but doesn't necessarily know the full extent. They just don't get in the way. Can an accomplice be charged with conspiracy? Potentially. Depends on how much they know. You can get to that point where you know enough. The Pinkerton doctrine is a very liberal application. It's a very broad application. Saying, look, if you know enough, we're going to go in there. Some states like it, some states don't. Criminal liability that come down to the public policy. That's why some states like it and some don't. What type of liability should be imposed on an industry that sells prescription drugs or firearms? That's how far does that reach? How far should we let it reach? And that's that's a definite philosophical and policy question, because do we want to put somebody, and there are people in prison for life without parole, we don't do death penalty anymore, who just drives the getaway car, but they're going to reap the rewards. I think a lot of it does boil down to your prior knowledge. If you know ahead of time that there's going to be an armed robbery, you should be considered part of the conspiracy, and you're putting it together. You're part of the problem. So, and with that said, that's kind of what that's what this week's all about. We're looking at anybody other than the principal. What's their responsibility? And then, because it can apply to any crime, conspiracy to commit or accomplice liability, how much act and mens rea do you have to do this? So, as usual, doors open, Zoom's open. Let me know if you have any problems, and we'll see what happens from there. Chapter 5 gets into a little more meat of criminal law. So see you next time.